is Paul. Yes. This is a copy of the Washington State Constitution. Yeah. Now, I just seen it here. Oh, Section 27. Treason against the state shall consist only in levying war against the state or adhering to its enemies or giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the overt act or confession in open court. Yeah. Now, I've mentioned this in the past. Yes. This concept of not admitting the evidence is treason. Now, all it takes is two witnesses to say that you refuse to acknowledge my rights as an American citizen and that your allegiance is to your family. Now, we're having a little war today. Section 27 of the Washington State Constitution. Now, similar to Article 1, Section 24 of the Oregon Constitution, Article 1, Section 26 of Hill's proposed Constitution at the convention. Both Delegate Alan Weir's proposal in the committee reported regarding treason were the same as the final provision approved, except for minor word changes. The legislative provision regarding treason is found in RCW 9.82.010, which mirrors Section 27. According to this statute, which was passed in 1909, treason against the state is a crime punishable by death. Now, not surprisingly, no one has ever been charged with treason in Washington State. The only publicized or published case opinion ever to mention Section 27 is a case involving a defendant convicted of perjury. In discussing the burden of proof in perjury cases, the court mentioned the common law put perjury and treason in a class by themselves. So firm was the rule with respect to treason that it was written into our state constitution that no person could be convicted of treason except upon the testimony of two witnesses, State versus Wallace, 1957. Now, this concept of you having the evidence since June 16th of 2017, making me go to court for the last 15 months, and then acting like you're going to get me admitted to a mental facility without spending the rest of your lives in prison. Treason. Now, I just wanted to make sure that for every oath of office, that thinks that it's okay for them to allow for the prosecution by information, yes, Section 25, offenses hereto required to be prosecuted by indictment may be prosecuted by information or by indictment and shall be prescribed by law. This whole concept of using the criminal complaint is prosecution by information. Yes. Now, I gave you the example of 2 judicial days from August 2nd to August 8th, Brett Roberts. Yes. Then I gave you the example that I didn't miss the court hearing. I informed law enforcement that I wanted the summons requiring me to appear. And then you kept making me have to go to court when no one would admit the evidence that I was not in Brennan, Washington, and I was not cyber stalking. Yes. Now, there's nothing lewd or lascivious in any of the communications that I've emailed. So you're prosecuting me by the information that I was in Brennan, Washington on June 16th of 2017, and that, as the state has said, a third-party co-worker had received emails from me that were informing law enforcement of my civil rights being violated? Yeah. Informing law enforcement of forgery, fraud, and misrepresentation. Now, I'm kind of thinking that you should, Section 22, rights of the accused. In criminal prosecution, the accused shall have the right to appear and defend in person or by counsel to demand the nature and cause of the accusation against him, to have a copy thereof, to testify in his own behalf, to meet the witnesses against him face to face, to have compulsory process to compel the attendance of witnesses in his own behalf, to have a speedy public trial by an impartial jury of the county in which the offense is charged to have been committed, and the right to appeal in all cases. Now, I'm going to a cell hearing where you're wanting to prove that I'm delusional for no. Well, that's what it's for. You're making me go to court to prove that I'm delusional when I just emailed today the actual documentation that I wasn't in Brennan, Washington. Now, you have not protected any of my rights as the accused. The police department has not admitted the evidence because I would have gotten a phone call, yes, telling me that there's no court hearing tomorrow. But instead, your allegiance is to your family. Now, you're going to all find yourselves in prison, yes, because I need 2 witnesses that have heard the sheriff right now say that, well, we don't have jurisdiction to admit to the court that we just got an email with the actual evidence that the accused was not in Brennan, Washington. Now, there is nothing in that email that is lewd or lascivious. So for you to obligate me to go to a court here